Okay, so it's very good morning to all of you. So as of all you know that our college Budge Institute of Technology is organizing an online session on IPR and patent design filing jointly with the RGNIIPM, which is the Rajiv Gandhi National Institute of Intellectual Property Management. Rajiv Gandhi National Institute of Intellectual Property Management has been established at Nagpur as a national center of excellence for training, management, research, education in the field of intellectual property rights. See, Nirmalla Sinha is today's speaker for this program. So we have also with us our respected Dean of Academics, Sir, Professor Dr. Narendranath Jana, Sir. Welcome, Professor Sinha and Jana, Sir. Professor Sinha is working for more than 20 years in central government office under the Patent Office, Ministry of Commerce and Industry, Property, working as Joint Controller of Patents and Designs, and Head of Office in RGNIIPM Nagpur from November 2021, which is the only central government national IPR training institute in India. He has done also BTech Electronics from Nagpur University and MTech in Material Science, Material Engineering from Jadavpur University. He has also done 1 year executive program in business management from IIM Calcutta. After that, he joined Patent Office in the year 2002 as Examiner of Patents and Design, Group A Gazetted Officer. Then he promoted to the Assistant Controller of Patents and Design in Patent Office Delhi in January 2009. So in 2021, he promoted to Joint Controller of Patents and Designs in RGNIIPM Nagpur. He has knowledge of foreign languages like French, Spanish, Russian, and delivers many lectures on IPR in various parts of the country. He was deputed twice for training at European Patent Office, Netherlands, and at World Intellectual Property Organization, Switzerland, on examinations and CDIP issues respectively. Now I request our Dean of Academics, Professor Dr. Narendranath Jana, sir, to say about few words about the today's session. Welcome, Professor Jana, in this program. Sir, you have to unmute yourself, sir. Yes. Hello, sir.
Thank
Yes.
you, Jayanto.
Yes, sir.
On behalf of BBIT, Budge Institute of Technology, that is in Budge, we welcome Dr. Sinha to have this session. As you know, BBIT was established in 2009, so we are on the 13th year of our existence. Now, since last 2 years, especially after COVID-19, we have had a lot of changes in terms of our organogram, in terms of faculty quality, faculty quantity. Now, as far as faculty quality is concerned, we have recruited many PhD faculty where we are expecting that most of them do work on some kind of patent as well as research work. So in that sense, last 2 years we have seen, yes, there are increase in number of filing the IPR and other things. So, and as a part of, let us say, NAC accreditation, as that is one of the criteria to be a part of this. So regular interaction on this particular aspect, including research methodology, entrepreneurship development. So this kind of workshop definitely will help the junior teachers to really come out with various products which is innovative in nature. So welcome Dr. Sinha to this particular session where most of us would be getting enriched, and I would wish this program will have a grand success. So took a lot of initiative, including our Dean R&D, and we have already, let us say, had some kind of commitment that this kind of program will be done very frequently, means as a regular interval, so that teachers are always enriched with the latest development, what is going on this front. So thank you, sir, for sparing your time to be with us. So I wish a grand success of this program. Thank you, everyone.
Thank you, Jana sir, for your motivating speech regarding this particular session on the IPR. So I now request Dr. Professor Sinha to start the session.
Yeah, thank you, Mr. Jayanto, and thank you, Professor Jana, for organizing this type of program in your institute. We will get to know more about IPR, because IPR is a, and I believe that institute like you can benefit yourself by knowing more about IPR, the filing procedure, and the importance of IPR, and what significance does it carry in today's world. What are the challenges you face and how you tackle those challenges. We will try to give you, we will try to share our knowledge with you and give you an introduction of intellectual property right. Since this is a free program which has been organized under NIPM, so we have only a limitation of time of 1 hour, and within 1 hour we have to, and which will be followed by a short session of question and answers, where you will try to, we will try to clarify your doubts. But we will always encourage you to enroll for our paid sessions, which we conduct from time to time, almost every month. Our institute at Nagpur, the Rajiv Gandhi National Institute of Intellectual Property Management, organizes paid programs, online programs, and offline programs as well. So you are encouraged, if you cannot enroll for offline program, at least enroll for our online program to know the IPR in depth, and it will aid in your patent filing, and it will help you improve your IP portfolio, because every faculty member or every higher student who is indulging in research and development, he has a, he needs to know about this IP filing, intellectual property filing procedure, so that patent filing procedure, so that you can benefit yourself, and within a shorter time your patent will be granted. Otherwise it may take a whole lot of time, and it may be pending before the patent office for as long as 5 years. So that will not be in your interest. So in this way, so I will just share with you a slide which you, so I think it is visible to all of you.
Yes, sir.
Yeah, yeah, okay. So we are there. RGNIIPM is there in Facebook. You can see our Facebook social media page, where we keep on giving our programs and advertising our programs. We are also there on Twitter, where departmental programs also are arranged by our RGNIIPM. This is a centrally located institute in central India, so that all the branches all the four metros like Chennai and Mumbai. So all the officers can come down to the central India, Nagpur, and take the training. That is why it is located in Nagpur. It is located from the year 2002, and I also joined this office in 2002. So I was the first batch to take the training in this institute in 2002. And from that time onwards, it has RGNIIPM has already completed 20 years of existence. And before this, we were located in Seminary Hills at Nagpur, but now we are located at Civil Lines area. We have an independent building of ours. So we are functioning under the Ministry of Commerce and Industry, and the department is called the DPIIT, that is the Department of Promotion of Industrial and Internal Trade. And our chief is called the Controller General of Patents, Designs and Trademarks. And the patent office is located, as I said, on the 4 metros. And trademark registry is along with the 4 metros, Mumbai, Delhi, Calcutta, Chennai. It is also located in Ahmedabad. So designs registry is located in Calcutta, and the filing office is all in all 4 metros, but the examination office only takes place at Calcutta. The geographical indications registry is at Chennai, and nowadays it is trying to, the department is trying to distribute the powers in many offices. So at present it is in Chennai. Copyright office is in Delhi. The semiconductor IC layout design registry is in Delhi, and the training academy, which from RGNIIPM, is located in Nagpur. So India, this is how our IP offices look like, and the 4 metros, you can see and appreciate them. This is our training center at Nagpur. from where I am currently addressing you at present. And this is our website, ipindia.gov.in. It contains multiple informations, many informations on patents, designs, trademarks, geographical indications. So you are advised, encouraged to go to our website and visit it, and you will get HTML format of the Patent Act in HTML form. You will also have to, if you want to do a public search on patent latest trend of inventions, you can also do by means of keywords, and as well as you can access the weekly journals which are published by the patent office and the design office. Weekly journals are accessible, as well as you can do trademark search. Also controller decision, suppose your case is offered a some stage under section 14 of the Patents Act, and then the controller, you controller during the hearing. So the controller passes a decision. Now the controller's decision is also available. It is uploaded in the module and it is available in the website. So you are available. Also, you can track your patent application. It is a dynamic utility which allows you to real time to track the status of your patent application, whether it is pending before the examiner or it is pending before the controller, or hearing is to take place, or hearing in notice has been issued, and your or written submissions are awaited, or whatever. Even if pre-grant opposition are filed, then also you get to know by means of tracking the online status, real-time status of your patent application, which is available from our website ipindia.gov.in. So intellectual property is a type of intangible property. It is an intangible property because you cannot feel it or touch it. So one which is can be felt or touched is called tangible, but one which cannot be felt or touched is called intangible. So tangible properties are like gold, buildings, cars, automobiles. These are all tangible properties which you can touch. But intangible property is, intellectual property is a type of intangible property because you cannot touch it. It is by you get this intellectual right because it is a monopoly right awarded to you on behalf of your invention, to share your invention with the government office, with the patent office, whatever you have come up with. And then if we are satisfied that all the requirements of the invention and section 221J of the Act and the conditions of non-patentability fulfilled, that means your invention does not the purview of non-patentability. These also requirements are there. If they are complied with, forms and restriction is in place, then we proceed to grant your patent, which is the monopoly right, and we reward you with the monopoly right for a period of 20 years from the date of filing of the patent application. So this monopoly right is an intangible property, which is as good as a tangible property because you can execute agreements on basis of this intangible, on the basis of this patent right, on the basis of this monopoly right. You can license it to someone, interested parties, and you can earn huge royalties therefrom. So in this way, you manage your intellectual property. Now, intellectual property is further classified into industrial property and copyrights. Section 21J of the Act and the conditions of non-patentability. That means your invention does not the purview of non-patentability. These also requirements are there. If they are complied with, forms and restrictions in place, then we proceed to grant your patent, which is the monopoly right, and we reward you with the monopoly right for a period of 20 years from the date of filing of the patent application. So this monopoly right is an intangible property, which is as good as a tangible property because you can execute agreements on basis of this intangible, on the basis of this patent right, on the basis of this monopoly right. You can license it to someone interested parties, and you can earn huge royalties therefrom. So in this way, you do you manage your intellectual property. Now, industrial intellectual property is further classified into industrial property and copyrights. So, industrial property is further categorized patent, designs, trademark, and geographical indication. Now, copyright is meant for literary work, dramatic work, and artistic work, and also architectural plans, software codes. These are come under copyright. But if you come to the execution of software codes, you can claim them under patent, but you cannot claim the software code as such, like computer program part is able under 3K of the Patents Act. So it falls under the purview of non-patent. So in this way, you should be a computer program. So someone is putting his mic on.
একটা চ্যাট করলাম, দেখুন তো গেছে।
Jayanti, please ask him to mute himself.
Everybody is requested to please mute yourself. It's a request, please.
So, intellectual property means creative ideas and expressions of the human mind, and that is intellect, that have commercial value. So, you are having a creative idea and expression, and you want to seek a patent on it, and therefore you have to file the after almost when your research you will facilitate the patent office, you will help the patent office to dispose of the patent application, and it will be taken up on priority basis and for examination, and then the first examination will be report will be communicated to you within a period of 1 month. After that, you will be asked response to the first examination within 6 months from the date of FER, that is the first examination. So if you fail to file right the first 6 months or period of 6 plus 3, 9 months, then you lose your application. Your application will be treated as deemed to be abandoned under section.
শোনা যাচ্ছে স্যার, এখানে আটকে গেছে।
So in this way, so then you will appear before the controller through video conferencing, and then you will submit the written submissions both orally as well as you will upload the written submissions in the module. And then because electronic filing facility is there, so you can upload the email, written submissions to the module by means of a electronic digital signature. You have to got a digital signature for that, and then
क्या
ultimately the
क्लास अभी
controller will
पूरा
pass
भी
a
क्लास है ना
decision.
11:30
That
से,
decision will be
कितना
uploaded
कितना
on
है
YouTube. You can access the
ना
decision
कितना
from
स्टूडेंट
anywhere
है?
from by searching anywhere by
हाँ
IPRs giving by
20
providing
है।
the application number, and next it will be
चलो
either granted or it will be refused. So if it is granted or refused, sufficient reason will be given by the controller. Particularly if it is refused, sufficient reason has to be given by the controller, and that has to be a speaking order. Without reason he cannot
हाँ
refuse any application. So
क्लास
on
तो
the what
ऑफिशियली
the
होगा, तो हमारा तो
controller
ट्रेनिंग
said,
में ज्वाइन नहीं किया इस
sufficient
पे।
reasons, sufficient
हाँ
reasons that comply with
तो
the
लेके घूम क्यों रहे
requirements,
हैं
and
रास्ते
that is
बैठे?
why you have not
ओ सर का क्लास चल रहा है,
yet failed to
तो जाओ तो जाओ क्लास करो सर का। তার আগে ওয়েবিনার হবে, ওটা তো হচ্ছে, জয়েন করিস নি তো? তাহলে যে স্যার যদি বেরিয়ে যায় ক্লাসে বসে হল্লা করবি না, আমি 12টার সময় আসছি, ঠিক 12টা 12:30 না, ঠিক 12:30 না, ঠিক
So
আছে?
it is just like any other form of tangible
বাইরে
property,
ঘুরবি না,
gold,
12:30 पे
silver,
मार है
platinum,
बाहर मत
or
घूमो, क्लास पे
like
बैठो, अगर
land,
सर
buildings,
सही होएगा, ठीक है?
kata. So you can transact, you can make agreements in case of intellectual property, in case of patent, in case of design, trademarks. So creative expressions of the human mind
স্যার
or
শোনা যাচ্ছে?
intellect that have value. So it is, you are transforming
হ্যাঁ
your inventive ingenuity, your R&D into something
এটা পেছনে কীরকম
of
ব্যাকগ্রাউন্ড,
which will commercially benefit you. So it is an exclusive right which you are
পেছনে একটা
the
কীরকম
government
ব্যাকগ্রাউন্ড,
of
ভালোই
India,
লিখে
when it
রাখা
is
আছে।
granting a patent, it will award you with the patent certificate, and you will be awarded with the monopoly right for a period of 20 years from the date of filing of the patent application. So this monopoly right is an exclusive right. It excludes others from making, using, selling, or distributing the invention. No one can do it for a period of 20 years. The sole monopoly. So you are the Maharaja. And territorial right. Territorial right means that your right is applicable only in India. So if somebody is copying your invention and distributing it anywhere in India, you can challenge him in the appropriate court of jurisdiction. So suppose you have been
শেয়ার
awarded
করবো?
with a patent by the Calcutta patent. Okay? So you will challenge him in Calcutta High Court. So in this way, the division of Calcutta High Court, you will file a petition of
টিওসিটা বলছেন তো?
monopoly funds has to be filed in the Calcutta High Court. Similarly, if you are not is anybody is copying it from outside India, yeah, you if anybody is copying in Nepal or in Nepal, you do not have any patent right in Nepal because you did not file in that country. In that case, you have nothing to do in Nepal because you have not filed. But if you think that you will enter that country also, then you have to file the international application or the conventional
এটা শুনতে
application.
পাচ্ছেন?
You have to enter in that way in Nepal patent process. So if you file an
হ্যালো
international application, then it has to be filed in patent office Delhi
হ্যাঁ
and within 31 months, and select India as the international search authority. Enter the is
কথাটা খুব আটকে আটকে যাচ্ছে।
desirable, which is very, very important. So licensable right. Because why it is called a licensable right? Because you can license it to interested parties. That is why it is called a licensable right.
Yes, sir.
And you do the thing and economically you can earn from there by licensing your invention.
হ্যালো, হ্যাঁ,
So this
ক্যামেরাটা অফ করে দেবো?
it avoid application. So why do you go for intellectual property? Because the moment you file an application,
ঘুমাও
your
না, তাহলে আপনি
application,
ক্যামেরাটা অফ করে দিন।
you file a request for examination or it is allotted to an examiner and a computer. The examiner searches for their patent application. It is in the database which we have with us, in the subscribed database. He will check that whether your invention is already been published elsewhere in the world in some patent literature or in any journal or in any non-patent literature. So he will search extensively his available database which we have subscribed to, and then he will come to the conclusion that this search report and your invention is lacking in novelty or it is lacking in invention because it has already been cited in so and so prior art documents. So you will cite those documents and will send it in the FER. These objections will be raised in the FER, the first examination. In this way, we communicate the objection by means of the applicant by means of the first examination. Now, the more R&D, the more is the number of people. So, the more we will encourage you to file patent. So, before advertising in the journal, before publishing your invention in the journal, we always advise you that please, if you have in mind to get a patent, if you want to seek to get a monopoly right on invention, please file a patent for application for it and then go for any other publication. Please do go for patent application. Patent application only the cost.
না, শুনতে পাচ্ছি না, কেটে যাচ্ছে। হ্যালো, হ্যালো,
And this way, if you try to file the patent and if requirements under the section 1J and under section 3 of the Act are complete, we proceed to grant an invention and where we will get the monopoly of 20 years from the date of filing of your patent application. Moreover, if you file a patent application, that will be published in the journal. So the journal is a sea of information. Means it is a huge repository of information where if you go through the journal, you will search get those relevant inventions, consult the journal articles, and be able to stay abreast with the latest developments in technology. So in this way, you will benefit yourself by brushing your knowledge, by staying updated with the latest trend of technology in which you are pursuing your research and development. So in this way, you can utilize the published specification. It is a portion of scientific knowledge. Moreover, I want to say that you will be awarded with a monopoly right, right once you are awarded with a certificate. But this monopoly right will cease after the 9 years. So after filing, it will be a public property. It will no more be a
না না, কথা আটকে যাচ্ছে স্যার, একবার বলুন।
to exist, and everybody, you cannot exclude others from selling or so you have
হচ্ছে
or corporates for companies, this is 5 times more than that of individuals. Government of India has examination fee, the publication,
হ্যালো,
early publication fee for
কেটে যাচ্ছে
institutes
মানে
as
হ্যাঁ,
well. So institutes now do not have to pay like corporates. They can
কি
also
নেটটা
avail
চলে
the
যাচ্ছে
fee
খালি
as
বারবার,
that of an individual,
জুমটা
an
বেরিয়ে
individual
আবার লোডিং,
person. So
হ্যাঁ,
in the name of the institute, you can also file. Moreover, if you want the
এখানে
name,
আমার
your
এন্ডে
name
প্রবলেম
to be
করছে নাকি আমার
reflected in
এন্ডেই
the
প্রবলেম
patent
করছে,
certificate
কিছুটা
as
বারে
an
বারে গিয়ে আবার
inventor,
লোড হচ্ছে,
then you have to file Form 8. Only
হ্যাঁ,
then
তাহলে এখানেই
your
প্রবলেমটা
name will be
করছে,
reflected as an inventor in the patent certificate. Otherwise, the name of the applicant will only be there in
হ্যাঁ,
the patent certificate. Suppose the applicant is Budge Institute of Technology, so only
আচ্ছা,
the
হ্যাঁ,
patent
হ্যাঁ,
certificate will be in favor of patentee colon Budge Institute of Technology, and the date of filing of the invention will also be mentioned. Otherwise, if you want to,
হ্যাঁ,
in this way, you can
হ্যাঁ,
file Form 8 and with with the applicable fees, and you will get the benefit of like this. And making profits by,
তিনটে,
as I already
হ্যাঁ,
said, that uh, you have to uh, you have to use your invention to earn royalty and profits, and royalty on technology transfer or license. So exclusive privilege
হ্যাঁ,
or right is granted by the government, that is the patent office, to the patentee for 20 years from the date of filing
আচ্ছা,
or prior to, of the application. And for this period of 20 years, you can commercially exploit
হ্যাঁ,
your monopoly right. You can license it to interested parties, or you
আচ্ছা,
can sell your invention to somebody else, so that in return for a huge profit. So in this way, you commercially benefit from the
হুম,
invention. And this, in return, what you give to the government, you share your
হ্যাঁ,
invention with the government, and the government will keep it with, that is the patent office, and the patent office will keep with it. It will not require you to file the prototype of the invention. It will only require you to file the complete specification. It is a written description of the invention, the diagrams or the drawings of the invention, the claims of
হুম,
the invention, which demarcate your rights, the patent right, which is the area of your patent right, that will has to be expressed in words, that where
আচ্ছা,
you want the monopoly. Should
হুম,
not it
তাহলে
should
চ্যাপ্টার
not
3টা হচ্ছে বিল্ডিং,
infringe on somebody else's patent right. So that is why claim is drafting a claim is very important in
হ্যাঁ,
case
আমি লিখে রাখছি,
of a patent application. It
এগুলো
has to be
কমেন্ট,
done by some skilled patent agent,
হ্যাঁ,
or patent applicant has to be skilled enough. That is why we always encourage you to participate in programs, in our
তাহলে
online
চ্যাপ্টার 3 এরই
programs which we
অ্যাপ্লিকেশন পার্ট হচ্ছে
offer,
সিওপি,
or which
সিওপার আর সিও
general program
সার্কামস্ট্যান্স,
is being offered, which consists of 5 continuous
5 আর 6,
sessions.
হ্যাঁ,
That means 5-hour sessions, and for the fees is only rupees 500 per
হ্যাঁ,
participant. Also, the whole institute can participate, but provided we can we only with we will that is for fees of 25,000 for 50 participants altogether for a single day. And as a so this is a
না স্যার
theory of
লাস্টটা
right.
একবার বলুন,
So
শুনতে পেলাম
you,
না,
as I
কেটে
already
যাচ্ছে,
said, you cannot challenge India, because Indian patent grants you the patent certificate. It is only challengeable, or it is only applicable in India. If anybody is
হ্যালো,
infringing or copying your invention, marketing it, and it has come to your
দাদা শুনতে
notice,
পাচ্ছেন,
then you cannot challenge that person, because you do not have the monopoly right in that
হ্যালো,
market. There is no worldwide patent.
হ্যাঁ,
The
কেটে কেটে যাচ্ছে,
European
না একবার
Union
বলুন,
has
হুম,
applied for a EP patent, because it functions as a economic single economic entity. So EP patent, that is the Europe, be applicable in all the European countries, but there is no such combined
হ্যালো,
patent. What you should not use, suppose you have already devised it, you should not use in public or commercial use before filing the patent application, or market it, commercially use or market it, and you should not wait till the end of in the invention, because you have to until the invention is fully developed, because you have to in that case it will be someone else may copy it from you and he may file it before you, then it will be harder it will be difficult for you to prove it before the patent office that you are the rightful and original owner of your invention. That is why we always advise that even if it is an intermediate stage, your invention, then please go proceed for filing of the patent application. Even if it is a provisional application, it will be sufficient. But if it is not a if you do not file, then someone else may copy and file it before you. Then it will be difficult for you to establish that you are the true and rightful owner of your invention. So novel, your invention, novelty means it has your invention is not disclosed anywhere in the prior art. So that is means novelty. So our examiners who has been assigned, allotted the patent application, he will search in the database. He will find out if any prior art documents, similar prior art documents are there. If it is there and he has found out even some similarity, then he will cite that document in the first examination report and he will communicate it in the FER. Then you have to reply to the FER within 6 months. Then you have to say how your invention is different from what the prior art discloses. So you have to sufficiently justify that where your invention is different from the disclosure in the prior art. So prior art means anything that has been published, presented, or otherwise disclosed to the public before the date of filing of complete specification. So if anything is, so all things come, even if it is a patent literature or a non-patent literature, everything falls, even if it is an advertisement or it is a newspaper advertisement or a TV advertisement, everything comes under this prior art. If it is, it has to be done before the date of filing of complete specification. So you have to have possess the record and then it will be a prior art. Inventive step means that involves technical advancement compared to existing knowledge or economic significance. So technical advancement has to be there or economic significance has to be there. And if there is a technical advancement, suppose two inventions are cited. I said you that your invention has to be non-obvious. So suppose the examiner has found out on searching that two inventions which are two patent literature are there which are published before the date of this particular application. And if they are combined, on reading both of them, if they are combined, then any patent applicant or any person skilled in the art can arrive at the invention if he has of these two prior patent applications. In that case, it will lack inventive step. But if you satisfactorily show that no, it is not the case, some X factor is also there, which is not disclosed in these two applications, then you will successfully be able to reply to justify your reply for against this inventive step objection. So you have to show some X factor is extra is there, which is also not disclosed even if we add these two prior art publications. So in this way, you have to respond to the objections. So non-obviousness indications are surprising result has to be there, solution to a long-standing problem, fulfillment of a long-felt need, or a great technical progress. So filing of the application. Filing takes place either you can physically file application. Filing takes place either you can physically file or you have electronic filing facility which is available from 20th July 2007. So there are two ways of filing. And if you file it electronically, you have to have a digital signature and a net banking or a credit card or debit card, and you have to log in, select the entry, enter the details, save the draft, digitally sign the drafted entry, select the payment gateway, pay the prescribed fees. You will be provided with an acknowledgement slip or a generation of CBR. So generation of CBR, you have to keep the copy of CBR in the PDF format with you and in the digital format with you so that you can submit it. The CBR number and date is very important. you can submit it before the patent office, and if something goes amiss in our system, then you can show that you have already filed because you have the CBR number and date. Then we will search our records and we will find out what has gone amiss, and then we will try to track your invention and try to track your application and find it and do it okay, set it right. So design, the next thing is design. Design means, now patent means the function of the invention. So how, suppose an object, so the function of the object you are patenting because it is new, novel and industrially applicable. The next thing is design. Design means the external appearance of the object. Now the shape, configuration, pattern, color, ornamentation or composition of lines of color or combination applied to any article in 2D or 3D or in both forms. So design must be appealable to the eye. So design should be attractive to the eye, and it is a way in which an object attracts a customer by virtue of its aesthetic beauty. So it is not related to any functional or technical feature of the article, and because it is only related to the artistic view or the external view of the article. Moreover, when we award you a monopoly right on design, or the design registration is awarded originally for a period of 10 years, and with a further application, we can extend that up till 15 years, up to 15 years. So under section 2A, we are applying the design to any article of manufacture, which can be either artificial, partly artificial, and partly natural, and no damaged article or broken article can be applied for design. So you have to give up, it has to be whole article, and like you are seeing in the diagrams. So in this way, we have this design is applied on a whole article, not in any broken or part in
কখন শেষ করবে কে জানে, 5 মিনিট তো বড় কথা,
so
দেরি
you
করে
can
শুরু
see
হলো।
this slide. And then the unique selling point. So design is a unique selling point. You have to tell that what is different or unique in your design. When you are making the design application, you have to, how it is different from other designs, you have to mention in a few words. And then when you get the design right awarded, it will protect your design against copying and infringement by your competitors. Suppose your competitors, he has seen your product, he will make exactly the same product of the same design and not try to market it. Now this is not done, because he will eat away your profit, which is actually the product of your brain, of your ingenuity. So he should not do it. So in order to protect your product from being so copied or infringed, you have to file a design application for it with the design office at Calcutta, because Budge is situated in Calcutta. So you have to file with the Calcutta design office. And the design adds value to your product. It is a fair return on investment. It is a business asset. This monopoly right is an asset for you. The design is also a monopoly right. It is an asset for you, and it enables fair competition among all competitors, because it does not permit copying or imitation. So you cannot infringe others' designs, right? Therefore, you can file the design application and be awarded with the design registration. So suppose a design is having a technical effect, like a multi-door refrigerator. So a multi-door refrigerator has a technical effect, because one time you can make the upper portion freezing, the lower portion defreezing. In this way, you can, by turn of a knob, you can alter the defreezing and defreezing function, but this part will not be registerable under design. The design will be registered only for the external appearance of the product. It will not functionality of the product. So that we have to be take care of. Similarly, a foldable toothbrush, as you can see, or a self faucet, as you can see, these are all these may have technical effects, but they are not registrable under design. So design is of immense use for small business owners or startups. Everything comes with a package and every package has a design. Now, before launching a product into the market, all the corporates or even the MSMEs are very conscious that their product or design is not being copied by their unscrupulous competitors. So unscrupulous competitors, what do? They generate counterfeit things, they generate spurious products, they generate copies of original products, and they eat away the legal profit, the due profit of genuine business owners, genuine proprietors. So design, when you file an application, you have to, each application, each product is being classified, each article is classified into a different class. Suppose you are filing an application for pen cum torch. Now you have to either file it in the class of pen or in the class of torch or in both the classes. If you apply your design application for both the classes, then you have to pay double fees because you are applying in two classes. So the list of classes are mentioned here. Class 99 is the miscellaneous class. Classes 1 to 31 are the different classes which is available for Locarno classification of design, and it is available in our website ipindia.gov.in. So registration, first pre-registration formalities for design is, when an application, design application is filed, it is allotted to an examiner and controller, and it is being examined, and FER is being issued. So you get to know the objections which are outstanding for a design application. Next, you file a reply to the FER within 6 months, and if any objections or requirements are outstanding, then you are given a hearing under section 5 and 33 by the assistant registrar, who will offer you a hearing, and then by the controller, who will offer you a hearing, and then you will be you have to appear before the controller, and on satisfaction of all the addressing all the requirements, the controller will pass an order, and he will issue the design certificate or the registration certificate, and that will be published. That registration will be published in the journal. Now, after registration, you have to go on paying the renewal fees for 10 years. Every year, some renewal fees has to be paid. If you are an ordinary applicant, there is a fees. If you are a corporate entity, there is a legal entity, or other than natural person, there is another set of fees. So different fees has to be paid. And then restoration of lapse design is there. If somebody has failed to pay the renewal fee, due to which his design or the monopoly right in respect of design has lapsed due to non-payment of renewal fee, then it can be restored when there is a particular procedure to do that. Again, alteration of design is possible, assignment to other parties is possible, certified copies of design applications are possible. Such report of examiners can be available on payment of fees, and correction of genuine errors or obvious errors is also possible by proper application after registration. So this is the flowchart in which a design application proceeds from filing till acceptance. Filing of application, number and dating, examination. When examination occurs, we communicate the objection in the means of FER. Now, once there are no objection, then it will be, if you fail to file a response to the FER within 6 months, it will be considered as abandoned. Now, if you file a response to the FER, we will send it for re-examination to the examiner. We will judge that whether it is still whether the objections has been satisfactorily addressed or not. If it is satisfactorily addressed, then there will be proceed for acceptance. If it is they are still outstanding, then we will offer you hearing. Hearing, you have to appear for hearing. The hearing link will be sent to you. And the date and time will be sent to you. The hearing link you have to click and appear for the hearing through video conferencing. If you appear for the hearing, then and submit during the hearing that how you want to contest the objections which are still maintained by the examiner or the controller. Then you have to say, if it is you are not satisfied, you have to go, then the controller will review the case. If you are satisfied, then you are the case accepted by the controller, and he will publish it. He will generate a public certificate, and he will issue a registration certificate for design, and he will publish it in the journal. So this the examination takes place in Calcutta, whereas filing can be is possible in all the four offices: Delhi, Mumbai, Chennai, and Calcutta. Now the form 1 of design you can see I have shared with you, and this is the form 1 where you have to mention the class number, and you have to do. And then the perspective view in design you have to file the drawings. So all the drawings I have to file, the color drawings. And they show perspective view, front view, side view, bottom view, top view, all views you have to submit. Along with that, you have to give a novelty resides in the shape and configuration of the teapot. You have to mention in in a few words the newness or uniqueness of the design and how it is different from other design. And you have to we also say that no claim lies on any mechanical on any function of the particular design which is been asked for. Only the external appearance has been sought to be protected by design. Similarly, any article or word or trademark that is also not the subject of design application, so that has to be disclaimed. So both claim and disclaim has to be there. You are claiming the uniqueness on how it is different from other designs, and you are disclaiming all the trademarks, the functional part of the any which functional part comes under the purview of patent, and trademark is a separate entity thing, and letters, artistic things all come under the copyright, so they will not come under this design part. So for design, you have to file good drawings, which the background should be clear. There should be sufficient light, and it should not be dark. And in this way, you have to drawings both front and rear view, and then no multiple applications are not allowed in a single application. In a single design application, set like cup and saucer or chair and table are applicable, but outside that it is not applicable. Like also sets and variations of like a pair of gloves or a pair of shoes is acceptable, but three units of shoes are not acceptable, as we have shown in the figure. Similarly, depiction of living or dead person is also not available for design application. So what is not registrable as design, suppose there is a trademark or an artistic work which comes under copyright, like a drawing including a diagram, map, chart or plan, or engraving or photograph, whether or not such work possess artistic quality. So in this way, they come under copyright. Artistic things comes under copyright, and therefore book, jackets, calendars, these all come under copyright. Dressmaking patterns, greeting cards, labels, cartoons, cards, stamps, postcards, they all come under copyright. So I have already said you this, and so objections can be taken under section 2A if it is not an article of manufacture, if it is not natural, or it is not artificial or partly artificial, then objections can be taken. If it is not section 2D, that is design, if it is not related to if it is related to functional activities of the thing, it is not related to the external activity of the thing, appearance of the thing, then it can be objected under section 2D. If it is not original, then it can be objected under section 2G, that is, it is not true and original, it is a copy from somewhere else, and then it can be, or if it is under not novel, means it has elsewhere before the date of filing of the present application, the instant application, then or it is obscene or scandalous, or it is lacking in morality, or it is prejudice to the security of India. The objections are raised on this basis in the FER under these particular sections. Now, once a design is registered, then it will be published in the journal, and this publication will take place with the design number as it is given, the drawing will be given, the class number of design will be given, the applicant name and the address and the title and the date of registration will be given. I think we have already completed 1 hour, and we can go on, but we will then have to skip the question and answer part. So I think you can now start with the question answers. If anything is there, any doubts are there, you can ask me, because otherwise I will end it here.
Thank you, Professor Sinha, for your important speech on this particular IPR design, all these things. So, if anybody have any question regarding this,
All are requested to fill up the feedback form.
everybody is requested to mute yourself. If you have any question, you can ask it by unmuting you. And if anybody have any question regarding the today's session, in the chat box I have shared one feedback Google form link that is for your feedback about this particular session. I think, sir, nobody don't have any question. So I request our Dean of Research and Development, Professor Dr. Ashok Kumar Shah, to give the vote of thanks. Sir, are you here?
Yes. Am I audible?
Yes, you are audible, sir.
Good afternoon, everybody.
But sir, you are not visible.
On behalf of, yeah, am I visible?
No.
Okay, just 1 minute. Yeah.
Yeah, sure, sir.
Am I visible, sir?
No, you are not visible. Okay, you can carry on. No matter, your message will.
Okay. On behalf of Budge Institute of Technology, it is my pleasure to share vote of thanks from bottom of my heart to Sri Nirmala Sinha, Joint Controller of Patents and Design Government of India. It is we are indebted that you have just shared your precious time for our faculty member and students. Hopefully, we will have such more kind of sessions on patent filing, design, etc. I would like to thank the whole team of Institution Innovation Cell, especially Professor Jayanto Basak, Professor Ananya De, Professor Probal Chakravarti, and others for just arranging everything in such a short period of time. I would also like to thank the Director General Academics of our college and Dean of Academics of our college and Dean of Students, Professor Siladito sir, for for attending the seminar in spite of his so busy schedule. I would also like to thank the Registrar of Budge Institute of Technology also for extending support for today's program. I would also like to thank the management of my college. Without their support, today's program would not have been possible. And at last, I would like to thank all participants, my dear colleagues, students, and other staff members for attending the webinar today and making it a grand success. So thank you very much everybody for your precious time. And Nirmalo sir, in future also we will have interaction regarding how to do some more programs in future. So thank you very much.
Okay.
Over to you, Jayanto sir.
Okay, thank you, Dr. Ashok Kumar sir.
Sir, thank you,
Yes.
sir. Just I take 1 or 2 more minutes.
Yes, sir.
Take 1 or 2 minutes.
Sure.
I would also like to thank Mr. Nimalos Sinha sir for enlightening all of us regarding today's presentation. You have just enlightened us how to file patent and how much cost is there for filing a patent or design. And we have also just enlightened us the significance of guide, cases and right of intellectual property. Meaning of discovery and inventions, lots of people they are not aware. Actually, the meaning of discovery and inventions you have illustrated in such a nice way. Most common mistakes made by the inventors. Yeah, actually, this is very important because generally what we do, we publish the paper at first and then we file the patent later. So this is the mistake in general made by the patent filers. So take care of this and we try to sensitize this information among other colleagues also. And you have given the definitions of just design act under 2000, the importance of design and so many things we have learned today for that. Yeah, I'm conveying from bottom of my heart very sincere thanks to you, sir. We'll have more sessions in future. Thank you very much. Over to you, Jayanto, sir.
Yes, thank you very much, sir, Dr. Ashok Kumar Shaw, sir, our Dean of Academics, Dean of Research and Development. So, thank you, Professor Sinha, for your important talk about this particular how to file the patent, all these things. So, I think we can stop this session right now. If anybody have any particular comments or any kind of things you want to know, then you can free to ask. Okay, so thank you, Professor Sinha, for your important speech on this particular topic. So we may end now here, I think.
Thank you.
Thank you everybody for participating.
Thank you. Thank you very much.